morning. Please be seated. We are here for oral argument on In Re MH2023-004502. It's our number CV240275. That is a lot of numbers. Each side has 20 minutes, and you may keep whichever time you'd like for rebuttal, but it's up to you to decide when to try to cut us off and sit down to reserve enough time. One other thing, Justice Mary Elena Cruz has recused herself in this matter, so kindly, former Chief Justice Rebecca Birch is joining us to fill in, so we thank you as always, Justice Birch. With that, please begin.
Thank you, Your Honor, and good morning. My name is Sean Moore. I'm with the Maricopa County Attorney's Office, and I represent the petitioner in this case. I'm going to try and save at least 5 minutes for rebuttal. We filed the petition for review in this case because the opinion from the Court of Appeals made it essentially impossible for licensed behavioral health professionals to testify as acquaintance witnesses during involuntary commitment hearings. That ruling conflicts with both this court's prior holdings and with the controlling statutes, both of which indicate there is no problem with licensed behavioral health professionals testifying as acquaintance witnesses in many circumstances. The present case is among those circumstances where it was both correct and beneficial for the social worker, Michelle Garone, to testify as an acquaintance witness at patients' involuntary commitment hearing.
What prior case from this court does the Court of Appeals conflict with?
Matter of commitment, Your Honor. The one that said explicitly there's nothing barring medical personnel from testifying as acquaintance witnesses.
So I want to ask you something from your brief, which is you referred to this as classic layperson testimony. Do you want to walk that back a little bit? Because surely this person used social worker training and specialized training in performing the duties that were done here, right?
I don't think that I want to walk back that statement much at all, Your Honor, because even though she does come in with the pre-existing training she has as a social worker, the things that she testified to were, I think, classic lay witness testimony. That is, her own eyewitness personal observations of what she saw and she experienced throughout that conversation. That's classic lay witness testimony. It's not saying, oh, I read these records, and because of these records, I give this opinion. No, it was her own personal observations of what happened and of the behaviors that led her to file the application.
So you don't need any specialized training to know that you need to apply for, for the subsequent mental evaluations.
I don't think so, Your Honor. I mean, certainly not any medical training. I mean, that's a legal issue, what you need to do in order to begin the involuntary commitment process. I don't think it's within the social worker's medical training in order to know how to do that.
So you think a paraprofessional could sit there and ask these questions? Are you in treatment? Have you been to your clinic recently? What's the name of your doctor? So a paraprofessional could do that. It didn't need to be a licensed social worker.
Absolutely, Your Honor. You don't need to have specialized training to ask the sort of mundane questions that were the subject of the conversation in this case. These are questions like, how did you get here? What do you do in a typical day? Do you have a case manager? Things of this nature. It doesn't require specialized knowledge to ask these questions. And there's nothing in the record to indicate that she was performing any particularly specialized activity in asking the questions. She was just going to see, hey, is this guy okay? Does he need help? And I think that's a very basic thing that anyone can do.
Mr. Moore, I'm looking at the first two questions. I'll ask both counsel this. Is the first question moot? I mean, it is moot in the sense, of course, that the patient is no longer under care, at least under this order. But the legislature has amended 36539B to make it pretty explicit about who's entitled to be an acquaintance witness in this scenario. It'll go into effect, I guess, at the appropriate day, 90 days past, signee dies. So I'm not sure we're going to add anything by talking about what will be a past iteration of the statute. So do we need to address this at all, or shouldn't we just stick with the second question?
So I think that Your Honor does raise a good point that the legislature addressed this issue as, after the petition for review was filed. I do think that it's helpful to, my personal view is that the amendment to the statute didn't actually change anything. It just clarified what the statute already meant.
So what's it add then? What does it add for us to say what we thought the former version of the statute meant? It's not going to affect any cases. Probably these things move so quickly that I doubt there's anything still out there that from the old statute. Well, there might be a little bit, but any issues bubbling up. So why address this?
Well, I know that I have at least 3 appeals pending on this issue, Your Honor. So
And can't
on
we-
the acquaintance witness issue, not on
Yeah.
the privilege issue, assuming
Right.
that you're talking
If
about the
somebody is
acquaintance
affected,
issue.
though, by the acquaintance witness issue that's truly still affected under an order, can't we address it then if it comes up?
Probably, Your Honor.
Okay.
Yes. I do believe that the passage of SB 1354, which is what you're referring to, I do believe that pretty much entirely conforms with our view of the law, and so moving forward, hopefully that will be applied consistently with how I've argued. But for the purposes of this case, the patient in this case has already served the full term of his treatment, and so it's moot for him strictly. But as far as interpreting how these cases normally work, I still think it is valuable for the trial courts. You saw from the transcript, the trial court in this case said, hey, this issue pops up all the time. We'd really enjoy some clarification as to
Well, moving to the second issue, though, this is a little bit of a dense statute. And it's not, well, it's a little dense in terms of it starts out with the confidential relationship between a client and a licensee is the same as between an attorney and a client, when it
Right.
really isn't. But when and how is a confidential relationship formed between a social worker and a patient?
Right. So I understand that the circumstances are different, but the legislature told us that these privileges are the same, and so I say that we have to do our best to apply the principles applied to an attorney-client relationship to this situation. It says they are the same, and so if it would apply in the attorney-client situation, it should apply here, and if it wouldn't apply in the attorney-client situation, it wouldn't apply here. And so the test for when a privileged relationship arises in the attorney-client context is well settled. The test is that you look at the subjective but reasonable belief of the potential client as to whether they believe both parties intended to enter into a privileged relationship. And in this case, I think it's pretty clear using all objective indicia that was not the case here, that the parties did not intend to enter into a privileged relationship. On the first part of that, the patient's subjective belief, obviously patient did not testify that he believed that. I don't think it's necessary that he testify, but it's certainly a factor. So given that he didn't state his own subjective belief that there was this privileged relationship, we look to all of the objective facts and other indicia of whether or not the parties intended to enter into a privileged relationship. And I think it's pretty clear under those facts that there was not this intention.
Which
So-
particular facts would you point to?
It's a great question, Your Honor. I was just about to get to that.
I will throw you that segue.
I appreciate it. So first, patient never approached Ms. Garone for services, never asked her for services, and never intended to engage her for services. Ms. Garone specifically testified that she never provided any therapy or utilized her social work skills to try and help provide medical services to the patient. Patient never relied upon any privileged relationship to disclose any confidential information, to say, hey, here are my symptoms, here's what I've been experiencing, here's why I need help. And instead, he provided non-responses or nonsensical responses to all of the questions that were asked. And all of the questions were rather mundane. So given that neither party entered into the conversation with the intention of Ms. Garone providing medical assistance to patient, no such assistance was provided, and no confidences were exchanged, and it was only a single short, less than 30-minute conversation, that didn't recur. This is not an ongoing relationship. I think all of those indicate that there was no intention to form a privileged relationship.
Counsel, let me interrupt you for a second, too. Going back to the record, I couldn't find anywhere that actually told us what the questions were. There's just a reference to a conversation.
Right. So there are a couple. We don't know the full conversation, Your Honor. I will admit that, but there are some indications. In the application for evaluation, she says, when I asked him how he got to the hospital, he said, I got here by resting. When I asked him what he does in an average day, he said, I like drinking these waters. And then in the testimony itself at the hearing, she was asked, did you ask him if he has a case manager? She said yes. Did he provide a response? No. Did you ask him if he suffered from any mental illness? Yes. Did he respond? He responded yes, but provided no details. Yada. So we have some indication, but all of the evidence that we have of what that conversation was in the record, I think, is rather mundane and doesn't demonstrate the existence of a privileged relationship.
What weight, if any, should we give to this oft-referenced statement from the social worker, I'll call it the confidential warnings, that there's no confidential relationship being established here, you have the right to remain silent, this will be used against you in a court of law. I can't find that being a prophylactic device to preclude the finding of a confidential relationship anywhere.
Right. So I think that I most explicitly address this in the response to the amicus brief filed on Monday. And what I would say is that a disclaimer such as that is neither necessary nor sufficient to prevent the creation of a privileged relationship, but it is or can be an important factor to consider. Because remember, the test for an attorney-client relation, or whether an attorney-client privileged relationship is created, depends upon what the parties subjectively believe. And if one party comes in saying, hey, I don't want this to be a privileged relationship, I think that that should have some impact on the potential client, potential patient, as to what they believe the relationship is and what the nature of their conversation will be. So I think it's something that matters and should be taken into account, but it's not necessary and it's also not sufficient to prevent the creation of that relationship.
The Court of Appeals ruling here, if we were to adopt it, to find that there was a privileged and confidential and privileged relationship by virtue of MG's, the applicability of Section 3251 to MG's activities, given the fact that SB 1354 was a legislative response to the Court of Appeals decision, what would the effect of applying the Court of Appeals reasoning to MG when the legislature just said that MG in these circumstances is eligible to serve as an acquaintance witness, but then simultaneously apply 3251 to find the relationship to be confidential and privileged? Wouldn't that effectively nullify the amendment to 36539B?
I agree completely, Your Honor. I think that the legislature pretty explicitly stated in SB 1354 that they intend for people in MG's position, or Ms. Garone's position, to be able to testify as acquaintance witnesses, and applying the Court of Appeals logic in this case, I think would effectively bar social workers and licensed behavioral health professionals from ever testifying as acquaintance witnesses, because frankly it's difficult to imagine a factual scenario where they would be less likely to find a privileged relationship, right? Like unless a social worker just ran into this person on the street, I mean, there's really like almost no facts you could change to remove them further from a privileged relationship than here. So I think it would be an effective bar on them testifying, and I think that the legislature has pretty decisively said that we don't think that they should be barred. And I think that that's the correct way of going about it, right? I mean, Ms. Garone in this case, she was the person who was called upon and said, hey, can you take a look at this guy, see if he needs help? She went, she talked to him, and based upon her conversation, she thought that he needed involuntary treatment. She thought that he needed to go through the involuntary commitment process. And I think that it's valuable for the trial court to hear from the mouth of the person who first applied, here's what I saw, here are the things that led me to believe that this step was necessary. I mean, that's the exact kind of testimony that acquaintance witnesses are supposed to provide and regularly do provide in these cases. And so I think...
Let me ask you a question about that, though, because I take the other side's point that, this is a due process type issue. Someone's liberty is being restrained. And to use acquaintance witnesses in this context, a couple people who have a relatively brief encounter seems to impinge on those due process concerns. What's your response to that?
Well, I'm taking your Honor's asking, is the level of contact that she had with the patient sufficient to testify as an acquaintance witness?
Yes.
So I think that it is for a couple of reasons. One, as long all the statute requires, and remember, all of this is set up by statute. So as long as we're following the statute, then we're doing
unless there's a
things
problem with the statute.
Yes, Your Honor. So the statute only says you have to be acquainted with the patient at the time of the mental illness. And there are a number of cases saying that there's essentially no minimum amount of time. As long as you observe the signs and behaviors of mental illness that make you think that involuntary commitment is necessary, then that's sufficient to be an acquaintance witness. But I think more to the point, Your Honor, if the patient believes that the acquaintance witnesses that have been called have not witnessed sufficient behaviors and do not have sufficient background to testify as acquaintance witnesses, the answer is not to exclude them as witnesses before they've had the opportunity to testify. The answer is to cross-examine them at this hearing and then demonstrate that they do not have sufficient knowledge of these activities in order to be able to competently testify as an acquaintance witness. So I think that excluding them as a witness entirely before they've had an opportunity to testify to what they've actually observed is putting the cart before the horse, and that this should be addressed at the hearing and not beforehand by excluding the witness. And so I see I have about 5.5 minutes left. So if the court has any questions for me, I'm happy to.
I do have one question. You talked earlier about the parties' subjective beliefs and intentions, right? Which is throughout the case law with respect to the formation of the attorney-client privilege. What do we do with the fact, though, that this is a little bit different? This is a seriously mentally ill patient, or at least the application has been made. How do we deal with that test under these circumstances?
So I do agree that, just as a personal level, I do agree that there's a bit of a disconnect, that the legislature said we're supposed to consider this based on their subjective belief, but also the whole case is about them not being competent. I understand that there's a bit of conflict there, but I don't think that it's necessary that the person themselves testify that they believe to it, as long as all of the other facts and circumstances within that conversation or the series of conversations or meetings demonstrate that there is this privileged relationship. So we can see this in the 2019 case, for example, and I refer to them by years because there's just too many numbers. But the 2019 case, the patient in that case didn't testify that he thought that there was a privileged relationship, but the Court of Appeals still found it because they said, hey, this relationship has gone on over a dozen different meetings, and the social worker has provided professional services to this person, and so all this indicates that there is this relationship. And so I do think that the test is still workable within this context, even though there is that bit of a mental disconnect. The fact of the matter is the legislature told us this is the test we're supposed to apply, and so we apply it as best we can.
Just a quick follow-up on Justice King's question. Given the fact that she eventually recommends him for treatment, how much weight should we give her comments to him, asking him essentially to waive his rights, telling him, in effect, that what you say can be used against you?
Well, as Your Honor might not be surprised, I don't think that waiver analysis comes into this at all. I don't think that she was asking him to waive his rights or that any waiver occurred whatsoever. I think that it's just saying...
But you asked us to consider it as a factor.
Oh, yeah, you have to consider
in the reasonableness of his assumption. But how much weight should we give it when his answers were non-responsive? We don't know what shape this person was in.
I think it should be given certainly some weight, because it's given that the test is a subjective test, and even though there is this bit of mental disconnect, the test is, what do people reasonably expect out of this conversation? Did the parties intend to enter into this? And her saying, I do not intend to enter into a privileged relationship, I think is a factor that should certainly be considered, even though the patient's competence may be questioned.
Thank you.
Thank you.
Hey, Mr. Shipman.
May it please the court, my name is Robert Shipman, and I represent AR in this matter. The opinion in the Court of Appeals was correct to find that there was a privileged relationship between MG and AR. Social work involves the application of social work methods, principles, and techniques to try to, one, potentially restore a patient to functionality, or a second reason it can be used is to try to treat their mental disorders. Here, MG did exactly that. She assessed AR at the hospital. She came up with a conclusion about a level of care recommendation and discharge planning. The purpose of that is, first part, to try to improve functionality. We have a plan in future that might help him get to better functioning.
Mr. Shipman, before you get too far down the line on that, I'm wondering about the focus of the Court of Appeals in this case. I wonder if it was appropriate how they addressed whether there was a confidential relationship here. It seems like under 328283, that says the confidential relationship between a client and a licensee, same as between an attorney and a client. The Court of Appeals kind of went right to how do we figure that out? Well, we look at the definition of a client, receiving behavioral health services. That can include social work. This is how social work's defined, you know, and down the line. But there wasn't any analysis of whether a confidential relationship, as we would examine between an attorney and a client, exists. There was no use of like the Clemens type paradigm to make a decision of was there a relationship first. Did the Court of Appeals address that appropriately, deciding if there's a relationship by just looking at the definitions of client and services, or should they have gone under the Clemens kind of paradigm, which we would do with an attorney-client relationship?
Here, I would say we go with the plain language. You could go to the analysis, but it's a unique situation here, and AR in this situation, it's involuntary. He's an inpatient mental health facility. He has someone come and talk to him. He has no control over whether to talk again. There's an application that's filed. He's going to be taken to Valleywise Health and held involuntarily there. He has no control over whether it's MG that he talks to, other doctors. He has no control over that through the whole process. So I would say that the Court of Appeals was correct not to go there because this is a unique area where there's not a lot of control that AR had over any of this.
Well, let me just follow up on that. That's part of what I said earlier in response to Mr. Moore's one of his answers, that I find this is a confusing statute because it doesn't quite fit to have a relationship between someone servicing someone who could be seriously mentally ill with that of a competent client and attorney. It's difficult for the reasons that you just enunciated. But the legislature says that the confidential relationship is the same as between an attorney and a client. Doesn't that require us to look at, all right, how does the relationship between an attorney and a client formed? And it puts us into that position of saying, from his perspective, was a relationship formed? The Court of Appeals didn't go that direction, but are we required to do that by the language of 3283?
Well, I think you would have to look at it. But again, I do think it's a little different in that he's approached. But I think an attorney, for instance, could approach somebody about a case and start talking to him about it, and then the person talks to them, they interact, and that needs to be privileged. So I do think the court needs to look at it. But I don't think and I may be misreading where the court was going with this, the fact that AR was not just out on the street, knocked on a door where it said attorney and said, I want to talk to you.
Well, not so much even applying it to this case. I'm struggling with simply how to analyze any of these cases under 3283, putting them in the context of something akin to an attorney-client relationship when, as you point out, it can be very different with the clientele that we're dealing with here. So my question really is a simple one. We've said in the Clemens case most recently that here is what you need to establish a attorney-client relationship. It's from, as we were just talking about with Mr. Moore, we were talking about from the subjective viewpoint of the client. Has a relationship been formed? Is that the paradigm that we have to stick with under 3283?
I guess it would have been better if the legislator had clarified this, because it really is, to some extent, an apples to oranges situation. So I think the court could look to that for guidance, some of the subjective factors. But I do, as I started with, I do think the court has to take in mind the unique circumstances here, that AR wasn't completely free to continue to try to talk to MG if he wanted to. He couldn't have done that.
Where would we find that in the record? Those particular facts, where are they at in the record?
Well, it would be from, MG's own testimony. She said she met with him one time. She was sent to assess him. She did go and assess him. And then after that, she submitted the application.
Right. Beyond that, though, with the characterization you're giving of that interaction, and I'm asking because I couldn't find anything in the record that would really present that particular side of it, of how you're characterizing what AR must have felt or must have been dealing with in order to find that there was a confidential relationship formed here. I think if anything else, your argument thus far would suggest that AR may not have been free to avoid interacting with MG, but does that alone satisfy a confidential relationship?
I think it does, and I think, I know we're inferring a lot of things, you're right, there's not a lot of exact information in the record about exactly what was said, but I think based on the type of questions that we do know about from MG, that she asked him about a social worker, she asked him about if he was SMI, she went there to assess him, she went there to conduct a level of care recommendation. So from that, we can assume she's asking questions to gather information, that if she's going to put together that recommendation, she had to ask, at least attempt to ask some questions for that.
Well, and I think from what you're saying, I think from what you're saying, it gets down to whether or not she was actually acting as a social worker, engaged in social worker practice, and did she assess him. But I don't think we even get there if we can't find that there was a confidential relationship in the first place, because then she could testify to whatever it was that she did. Or am I misreading it?
I think you have to do the analysis, yes. But I do think here, based on what's been inferred from what was testified to, what we know about the proceeding, in the absence of the full conversation, it would have been great to have a full transcript of that conversation. This would have been much easier for everybody involved. But we are dealing with a population that has liberty interests at stake. There's due process protections there. I think the court should err on the side of applying the privilege unless there's something showing clearly there was no behavioral health practitioner-patient relationship and there was no waiver of the privilege. And here there's absolutely nothing to show that. In fact, everything that we can infer from it goes the other direction, that it appears that this was more than just somebody on the street talking to somebody that's on the street. It was a professional licensed social worker. She went there to assess them. It took place, she said, I think it was about 25, 30 minutes. So we know it wasn't just a 2 or 3 minute conversation. I get 20 minutes here. We're to talk about a lot in these 20 minutes. It was longer than this.
Was MH 2020 wrongly decided on this point, on the privilege point?
No, I think MH 2023 was rightly decided to find that the privilege applied. First, because I do think she was applying social work.
Well, not to interrupt, I think just.
2020.
2020.
And
the 2020
MH
case.
2020.
I do, and I put some of that in the brief, sorry, my mistake. I do think it was in that, some of the cases they referred to support the conclusion that their conclusion was basically, under these circumstances, it would have been unreasonable for somebody to think it was going to be privileged. But they pointed to a case, one of them was a Superior Court criminal case where a criminal defendant asked for an evaluation and to use at sentencing, intentionally to be disclosed and used at sentencing, and then came back later and didn't want to use it and claimed it was privileged. I think that's apples and oranges compared to what was going on in 2020. There was another case they used where it was somebody challenging the actual formal evaluating psychiatrists or psychologists in a mental health evaluation, claiming that that was privileged. So I do think what the cases MH 2020 used to come to that conclusion didn't support that ultimate conclusion. So I would argue that it was wrongly decided because there wasn't case law that supported the conclusion that they came to, that interaction wasn't privileged because, or under the circumstances it wasn't. I did want to go back. There were questions about when and how the privilege would apply to the new version of the statute. And my reading of State Bill 1354 is that it doesn't implicate and it doesn't do away with the privilege. It makes clear what was already before the law from this court in 1995. In MH 1425, this court pointed that out, that we don't want anyone to take our decisions to say that somebody that might have a professional license can't ever be an acquaintance witness. And that's exactly what the new statute does. It just says we're taking whether there's a license or not off the table. But that, to me, doesn't implicate the privilege for a few reasons. One, they're separate statutes. The court should give meaningful operation to both of them. And then also, if the legislature wanted to do that, they would have done it. They wouldn't have just said, we're not going to consider whether there's a license or not. They would say, also, the privilege is waived under these circumstances, and they chose not to do that. So I do think the privilege statute still applies, even with the change in the 539.
What does it mean? 3251.12 is the definition of the practice of social work. And it has very broad language, and I just wondered what your view of it was. The part that says that it can treat mental health, I get that, but then it also assists individuals to enhance or restore the ability to function emotionally or mentally. What does it mean to assist? And specifically, does that assistance have to be something more direct, like in restoring the emotional or mental functionality with someone, like almost a therapeutic type of scenario? Or can it be like it was more here, seemed to be more of assisting you in that I've decided I'm going to move this down the line and apply for an evaluation? Is it broad enough to be that as an assistance?
I would say it is broad enough for a few reasons. I mean, in my opinion, it was assisting. She did assist. She did file the application. She put together a level of discharge recommendation, discharge planning, things that were designed at assisting AR or any other patient in moving forward. And I would say it should be that narrow too, because there's a lot of times there's treatment teams, and at one point one person's giving input, then it goes to another person, then it can go back to that person. I don't think it should be drawn that narrowly, that it has to be an ongoing situation. I mean, it's example.
If it's that broad, I mean, it strikes me as, when would a social worker ever have an interaction then that's not going to be privileged? Because that is really broad. It strikes me that everything they do is just trying to assist, at least in that broad kind of concept that we were just discussing. And as the vice chief had said earlier, doesn't that then negate, really, the ability of a social worker to ever be an acquaintance witness?
I don't think so. And
can you think of a scenario in which a social worker could be an acquaintance witness where they didn't act in assisting an individual to enhance or restore the functionality emotionally or mentally?
Absolutely. And our argument from the beginning was never that a social worker couldn't be an acquaintance witness. It was that here, under these circumstances, MG was inappropriate to be an acquaintance witness. For instance, that day MG went to go meet with AR. It was in a facility. There probably were 20, 30 other patients potentially. She's a social worker. Now, she's going for a targeted purpose to talk to AR. I say it was evaluative. It was under the focus and spotlight of being evaluating when she was with AR. But she's walking down the hall, and there happens to be another patient she's not assigned to specifically to go examine that she notices in the corner, crying, yelling, talking to themselves. There, I would submit that's an appropriate acquaintance witness because it was incidental to what she was doing. She was trying to assist AR, but incidentally, if she came across just some facts that maybe in court, if she's called as an acquaintance witness then, it's a completely different scenario than if she's focused on the person, she's told, go find out what's wrong with them, put together a plan for them. It would be to me almost like, you watch a movie and the movie's an hour long, and you have somebody that watched the entire movie, and then tell them, well, now you only just tell us about the 10 minutes at the beginning. It's already past that. You've met with the person, you've done it for a targeted purpose. What you've done is no longer incidental. So what I would ask for is a standard that it has to be incidental. A social worker, maybe even a doctor, if they're going to be an acquaintance witness, their observations need to be incidental to what their job was in the case.
Which part of the definition 3251.12 is your are you contending that the evaluation would implicate this statute?
The evaluation as far as the privilege, or?
Yes, well, yeah, to trigger the creation of a confidential relationship that would give rise to privilege.
I would say A and B from the Court of Appeals opinion. To treat mental health, behavioral and emotional disorders, I mean, clearly she was helping to try to get an application in to start the court order treatment process where a patient in AR shoes could end up being court ordered to get treatment. So I say at that point she is working to try to treat that. And I would say also to assist to restore the ability to function physically, socially, emotionally, and mentally. She's talking about a level of care recommendation, a discharge plan. I would assume that's what's going to happen when they get out. Who are they going to work with? And that's assisting. They're setting that up. And whether she's still involved after that, under that plan, we'll never know. But I would say at that point she is assisting. And in this case, further, my position is MG's unilateral declaration that the privilege didn't apply is basically meaningless. The plain language of the statute is that the privilege is held by the patient, is who holds it. And another indication that the privilege is applying at that point is think about what they're doing at that point. If you didn't think it's potentially privileged at that moment, why are you coming in and saying it's not privileged? And that's exactly what they're doing. They are coming in and saying, there's a DTO exception, there's a DTS exception, but we're not talking about those. We're just saying anything that happens here is not privileged. Why are you going to do that unless you're thinking maybe what we're about to talk about might get into some privileged material, so we're going to try to disclaim this away ahead of time. And that's not the way the statute works. The statute said it's held by the patient. So I don't think it's appropriate to try to disclaim it away, and I also think it shows that, in fact, there is a relationship at that point, or basically an admission. Now, as far as MG being an acquaintance witness, in this case, I do understand the court's concern that with the new statute, it's going to have different language, so anything the court comes up with here might be, to some extent, moving forward. But I still would submit MG wasn't an appropriate acquaintance witness. She met with AR. It was evaluative in nature. It was focused on her for a particular AR for a particular purpose. It was very different than like what I said before about the kind of incidental observations. She went there for a particular reason. So another thing, in closing, I see my time is running down. I see there were three issues, essentially, in the Court of Appeals opinion. I would submit that the Court of Appeals was correct on all of them. MG should not have been an acquaintance witness here. One, because she couldn't give informal day-to-day observations about AR's behavior. She was essentially part and parcel in the commitment evaluation process. She interjected herself. I don't think you can draw a fine line that the state wants to draw on this. Because then if you draw that fine line and say any time before the application anyone can be a witness, there's old doctors that may have evaluated these people in prior petitions. Are they now allowed to be acquaintance witnesses? Possibly under that theory. And then also, in this case, using the plain language of the statutes, the privilege did apply, and she should have been precluded absent consent from AR to testify. Thank you.
Thank you, Mr. Shipman. Mr. Moore.
Really quickly, I want to address the first question that you asked, Mr. Shipman, which is sort of the interaction of the attorney-client privilege test in these statutes. And he said that this is a unique situation and the attorney-client privilege test doesn't really apply. I would disagree with that, Your Honor. I mean, you have to remember that this test for how the privilege is determined, I mean, this is in the behavioral health professional chapter of the statutes. I mean, it's almost necessarily true that every time this situation arises, there's going to be some kind of mental health issue going on with the patient, and that's going to be potentially relevant to how the patient perceives, not just that particular relationship, but reality. And so that's pretty much always going to be at least on the table for these cases. And I think that we, interpreting the statutes, have to assume that the legislature took all of that stuff into account when they made the rules that they did. And so I think that under those circumstances, we have to do our best to apply the attorney-client privilege test to these situations. Now, the practical implication of that is that much of what the Court of Appeals was talking about in its opinion is not particularly relevant to the privilege question. It's not relevant whether the patient fell under the definition of client under the statute, because the legislature tells us that's not relevant to whether or not the privilege existed. If the legislature wanted to say any client, any conversation between a professional and a client is privileged, they could have said that, but they didn't. Instead, they said the relationship is only privileged if it would be privileged under the attorney-client analysis standard. So I think you have to apply that test, and as I explained in response to Justice Montgomery's question, looking at all of the objective facts in this case, I don't think you can say that there was a privileged relationship.
Any idea why they added that language in? They amended the statute in 2006 to put in this business about the attorney-client relationship or privilege. Any idea why?
I have no personal insight on that, Your Honor. I'm not going to lie to you. I don't know why they did it, but all I know is what the test means and how it applies to this case. So I'm sorry I cannot enlighten you in that regard. But there are a couple other things that I wanted to address real quickly. Mr. Shipman talked about the incidental occurrence in the hallway. I think that this is a completely misapplied hypothetical, because it does, like, whether or not the social worker was sent to talk to the person or they randomly encountered them, it doesn't change the privilege analysis. Remember, you're seeing the privilege analysis through the eyes of the potential client. And so whether or not the social worker was sent or not sent, the patient's going to see the same thing. It's going to be someone walking up to me and asking me a bunch of questions. It's going to be the exact same thing. And how they perceive that conversation depends upon, what they intend to get from that relationship and what the social worker intends to bring. And I think that as long as all the same questions were asked and all the same intentions were there, it doesn't matter whether they intentionally talked or not. And I'm out of time.
You're out of time.
So I will
Thank you, Mr. Moore. Thank you, Mr. Shipman, for the argument and for the briefing. We'll take the matter under advisement, issue a ruling in due course, and we stand adjourned for the day.